has appealed a judge's decision that required he answer questions under oath.
Trial over payments between a landlord and
possibility of litigation, you have a duty to preserve evidence.
Now, the burden of proof seems to be on
evidence
him.
revealed in this affidavit, because police are saying that they—
Hold up. We are constantly hearing these words muttered on the news, on social media, and in day-to-day conversations. And you might be wondering, what in the world do all of these legal terms actually mean? My name's Mikayla, and I'm a lawyer who in this video will be teaching you some of the terms you've probably heard a lot of people say, but have never taken the time to learn the meaning of. Today, we're covering some of the basics. And I'll be posting one of these videos every single week in the month of February, where we'll be talking about more general terms, civil lawsuit specific terms, and criminal lawsuit specific terms that everyone needs to know. But for now, let's jump into the basics. Testify or testimony. To testify or give testimony is when a witness gives a formal, written, or spoken statement, usually in court. If you're ever called to be a witness in a case, your role is to provide testimony about something you've seen, heard, experienced, or have knowledge of. Under oath. In the legal world, an oath is a formal sworn promise or declaration that a person will testify truthfully. A common misconception in America is that you must swear an oath on a Bible. Well, you heard it here first. That is false. No US court can force a person to swear on a Bible or any religious text for that matter. You just have to swear to tell the truth, the whole truth, and nothing but the truth. And that's it. Paralegal, legal assistant, and case manager. These are all various members of the legal staff that work for the attorney who handles your case. And the amount of work these people do is just so incredibly invaluable. They will often be the ones most knowledgeable about your case because they are handling the day-to-day communications with you, the lawyers opposing you, and the court. They do scheduling, they stay up to date on medical records and treatment records. They often draft some legal documents. I mean, the support that they provide attorneys, the list can go on and on. So always be kind to the support staff because without them, your lawyer could not do the job they do. Trust me on this one. Jury trial versus bench trial. When you hear about a celebrity or someone you know going to trial, they're most likely going to a jury trial. A jury is a group of people pulled from your society. You might have heard of it as a jury of your peers, and their job is to make the final determination in a trial. If it's criminal, the jury decides whether the defendant is guilty or not guilty. And if it's civil, the jury decides whether the defendant is liable or not liable. However, there's a second type of trial called a bench trial. And you may not hear about bench trials nearly as much because they only make up 10 to 15% of all trials. In a bench trial, instead of having a jury of your peers decide your fate, it all comes down to the judge. Both sides present their case like usual, but the judge who's presiding over the case makes the sole decision on guilt or liability. Sometimes this can be a terrible idea, but depending on the jurisdiction the trial is happening in, it can be beneficial. It's all part of your strategy, baby. Pre-suit. Pre-suit just means prior to the initiation of a lawsuit. You might have heard terms such as pre-suit demand or pre-suit settlement, which are terms that we'll cover in videos later this month. But for now, just know that pre-suit means before a lawsuit is initiated. Affidavit. An affidavit is a written statement of fact that is provided, you guessed it, under oath. It is a voluntary statement given by someone who wants to attest to something or declare that something is a fact. Jail versus prison. This is such a simple thing that so many people mix up all the time. People use them interchangeably when in fact, they are not interchangeable. While there are many differences, you can feel confident in saying that if somebody is being sentenced for a crime for less than a year, they're going to jail. And if they're being sentenced for that crime for more than a year, they're going to prison. For example, you're probably not going to prison for jaywalking, and you're hopefully not going to jail for mass murder. And if you are, then the system is a lot more messed up than I realized. Court reporter. A court reporter is known as the guardian of the record. The record being the events that take place or the words that are spoken during something like a court hearing or a trial. The job of the court reporter is to transcribe or type out every single word that is spoken so that people have a record they can look back on at a later date. They are so incredibly essential, and again, another invaluable asset to the legal system. Burden of proof. A burden of proof is a party's legal obligation to prove a claim and the threshold they must meet in order to successfully do so. In a criminal case, the state or the prosecution has the burden of proving the defendant is guilty, and the threshold they must meet in order to convince the jury or the judge that the defendant is guilty is beyond a reasonable doubt. It is the highest standard in our legal system and basically requires the prosecution to prove that there is no reasonable explanation other than the one that they're claiming. On the other hand, the burden of proof the plaintiff must prove in a civil case is much lower. The plaintiff is the one who initiates the lawsuit in a civil case, and they must prove their claims by a preponderance of the evidence. That's just a super fancy way of saying more likely than not. 50% and a feather, some might say. Civil and criminal standards are very different, and they're helpful to know in the event you ever find yourself in a lawsuit. Spoliation. The moment you are put on notice or become aware that something such as an object may be used as evidence in a lawsuit, you must not under any circumstances alter, discard, destroy, or in any way manipulate that evidence. If you were to alter a piece of potential evidence, you have now spoliated that evidence. This can and will work against you in numerous different ways, all the way from being sanctioned by the court and up to the court finding in favor of the opposing party. Just don't do it. If you even have an inkling that something may be used as evidence in a case in the future, do everything you can to preserve it and thank me later. Thank you guys so much for watching. Happy Black History Month. And before you go, be sure to click on the video on the screen right now where I tell you guys the story of how I was racially profiled and how that led to me going to law school completely for free. Be sure you're subscribed so you don't miss out on the rest of my videos in this series, and I will see you all in my next video. Goodbye and go thrive.